Let's talk about product liability. So first of all, what is product liability? Product liability is the area of law that holds manufacturers, distributors, retailers, and other people that are responsible along the chain of distribution of a product legally responsible for injuries that are caused by the product. Now, those injuries can be the result of a design defect, a manufacturing defect, or what we call a marketing defect. And we'll go through each one of those specifically. But first, let's talk about why it's important to understand the legal framework of product liability. So first of all, product liability laws encourage product safety. If every manufacturer was out there making super dangerous products for our kids and our family members, people would be getting hurt all the time. Part of the reason that in the United States we have safe products is because of these laws. There's strict liability, which we'll talk about later, but these manufacturers and distributors are strictly liable for injuries that are caused by their products if you can prove that they were defective in some way. The second reason is we want to empower consumers to understand their rights. These corporations that make these products are many times multinational, billionaire, trillionaire companies that are able to sort of control the courtroom and control the legal process. If you as a consumer understand your rights, if you're injured from a product, you have a lot better chance of standing up to these companies and understanding that you can hire a lawyer at no cost to you to pursue these companies in court for causing you injuries or causing injuries to your children. We also want to encourage transparency. So we want the companies to be honest and forthcoming about their products and make sure that everything that they do, we know about how the product is designed, how it gets manufactured, what's in the product. We have a lot of government agencies that help to sort of ferret out bad chemicals that are in our products. But you know, the advantage to a product liability law is if a distributor brings it over from China and China did something that they put lead in a toy, for example, and so that product is now defective and it might cause injury to somebody. It's very hard to get over to, you know, it's impossible to sue that Chinese company that made it. But if you can go to the distributor here in America that distributed that product and say, hey, you distributed a product that was defective and it hurt somebody, we're going to hold you legally responsible for it. It makes those companies have to sort of do their own legwork in vetting the products that they're bringing over. So it helps our government agencies to not have to do all that work when we have what's called a private right of enforcement, which is your right to sue one of these companies. And finally, we want consumers in America to have confidence in the products they're buying. It's good for the economy. It's good for the economy for people to go out and buy products from, you know, these big box stores, knowing that most likely they're safe, and in the event that they're not safe, they're going to be able to hold these companies legally responsible for the injuries that they cause. So now we're going to talk about the different kinds of product liability cases that there are. So the first one we'll talk about is manufacturing defects. These are usually one-offs. They happen during the manufacturing process. So it's not as if every single one in that was ever produced by the company is defective. These are generally things that, you know, a wire was installed wrong in something. And we'll go through a few examples, but this is during the manufacturing process, something happened that caused that item or product to become defective and therefore dangerous, and then it caused an injury. And then we allege a manufacturing defect. So some examples of that are a defective brake pad, right? So not every brake pad that this company made was defective. This one was, and it caused a car accident. A contaminated food product is an example of a manufacturing defect. As we talked about, something with faulty wiring, that's a manufacturing defect usually. And then a broken toy or something that's made containing dangerous small parts or chemicals that weren't supposed to be there, but because of something along the assembly line happened and it got in, now you have a manufacturing defect that caused an injury. The second one is a design defect. So this is usually every product that they made was designed defectively. So the design of a product needs to be safe. When they design a product, they need to design it so that anybody can use it for its intended purpose, and you most likely are not going to get hurt. If they've designed a product negligently, now you have a defective design that can cause an injury. So Unlike a manufacturing defect where only a few of those products might be defective, almost all of the products in a design defect case are defective. So some examples of that are cars with defective gas tanks. Let's say they install the wrong defective gas tank in every single one of those cars. Now you have a product liability case against the car manufacturer for a design defect. Same thing we talked about before, toys with small parts, but this time the small parts were supposed to be there. The toy causes a choking hazard. It's a toy made for a 3-year-old, and it's got a bunch of little pieces that fall off, and when you touch it a certain way and they're playing with it as they're supposed to do, and then they choke on those pieces, they designed that product in a defective way. Defective electrical products that overheat, even though they were manufactured correctly, they were manufactured to the specifications, but because of the way they were designed, they get too hot, they cause fires, they light clothes on fire, they light people's hair on fire, whatever the case may be. All of the products were designed that way, so they overheat. Finally, an example would be a lawnmower without the proper safety guard. So when a lawnmower is going, it's supposed to have a safety guard behind it. There have been times when manufacturers have produced a lawnmower that doesn't have that safety guard, and they were able to get sued because they should have had a safety guard there in place when they designed that product so that wasn't defective and didn't cause anybody injuries. Finally, we'll talk about marketing defects. So these are generally broken down into 2 categories, and one is the failure to warn and inadequate instructions. So failure to warn is something they know or should know that's dangerous about a product, and they fail to tell people about it. We'll go over some examples of that. And then the second one's inadequate instructions. So I'm sure you guys have all bought a product, gotten an instruction manual, and tells you how to use it. If you buy one of these products, and let's say the instruction manual doesn't tell you what to do, or it causes you to have an injury because they didn't tell you exactly the right way to do it, that would be inadequate instructions. So that's different than it wasn't manufactured that way. So maybe the manufacturing of the product's fine. It wasn't designed effectively. Maybe the design of the product is fine, but the way they marketed the product, the way they either didn't tell you warn you about how the product could be dangerous, or inadequately instructed you on how to use the product. Examples of this would be medications that fail to include warning labels about potential side effects. That's a marketing defect. Toys or household products that do not carry age-appropriate safety warnings, leading to children using those things or ingesting something that's toxic or a chemical. That would be a marketing defect. Electrical appliances that fail to include proper instructions for installation or use. And then cleaning products that maybe don't tell you, hey, when you use this cleaning product, you need to have gloves on, for example, or you need to have eye protection on, or you need to have good ventilation. And then so they don't have that warning. Somebody uses the product, they get injured, they sue because of a marketing defect for that injury. So product liability claims are a little bit different than our general claims like car accident claims or slip and fall claims or medical malpractice claims. In a product liability claim, it's called strict liability. So all you have to prove is that that person manufactured it, distributed it, or was a retailer. And then you have to prove that the product was defective in some way in the ways that we've talked about: design, marketing, manufacturing. And if you can do those things and you have an injury, then you don't have to prove that they did anything else that was negligent. So it's strict liability all the way up the chain. So, and you also don't have to prove that they intended to cause you harm. Even if they didn't do it on purpose, you don't have to prove that in a strict liability claim. Under strict liability, as we talked about, anybody up the chain who provided that product can be held liable. So we focus in these cases on the actual product, not the defendant's actions. So was the product itself in some way defective, not did the defendant do something that was negligent. I mean, it's kind of a meaningless distinction in some ways. I mean, for lawyers, it's not. When we get in the courtroom, there's a lot of reasons that we have to distinguish these cases from a general negligence case. But, essentially, we got to prove they did something wrong in the design, manufacture, or marketing. So there is a little bit that you have to prove that the actual defendant did something wrong. But because it flows downstream, if the manufacturer designed it defectively, let's say, but it got sold to you at a big box store, you can still sue the big box store. So we're focusing on the product. We're not focusing on the big box store because they maybe didn't do anything wrong except, bring this product into their store that was defective and caused an injury. The main difference in Florida on products liability claims, and most of the time it's very similar to other states. This is sort of black letter law. It's all the same. But in Florida, we have what's called comparative fault. So there's an argument that the new House bill that was took effect as of March 25th, it went into March 24th, 2023. And then the next day, March 25th, 2023, sort of started to have legal teeth. There's an argument that if a plaintiff is over 50% at fault for their own injury, that they get no recovery. Now, I think we can make a distinction here with the products liability case, but the case law is still evolving on that, so we're not completely sure. But what we do know is that Florida is a comparative fault state, so the defendant, even in a product liability case, can come in and say, well, look, you have some fault here, even though it is strict liability. They have liability. They can say you used the product in the wrong way, and not for its intended use. We have statutes of limitations. So again, there's an argument here because of the new law, whether the statute is 2 or 4 years. It's my position that the statute on a products liability claim is still 4 years. However, it's better safe than sorry, and you want to treat that claim as if it has a 2-year statute of limitations because, again, the case law is evolving on that. Also, punitive damages in Florida. So these are damages. You can look up what's called the Pinto case. This was where Ford was producing a car that they knew was defective and they knew it was killing people. And what happened is they got sued, and they got sued for punitive damages. So in this case, it was, a jury found that their behavior was so egregious and so outrageous that they knew that this car was dangerous and they kept producing it anyway, that, hey, we're going to give you what's called punitive damages. Those are damages that go above and beyond what the person suffered for, injury, medical bills, pain and suffering. This goes beyond that. This is just to punish the company. Those can be in the millions of dollars sometimes when you need to punish a company because, sending a financial message to Amazon, right, is going to be different than sending a financial message to a small mom and pop store. That Amazon judgment has to be higher. So in Florida, there's a limitation on punitive damages. In Florida, they're capped at 3 times the amount of the compensatory damages. So if you only get, let's say, $1 million, they're going to cap out your punitive damages at $3 million. It's an important thing because, in my opinion, we're not holding companies as accountable as we should. And then the judges can reduce those punitive damages awards. There's also an economic loss rule. So Florida follows the economic loss rule so a product liability claim has to actually cause you property damage or cause you physical injury. It can't just cause you an economic loss in order for you to bring a products liability case. And then finally, we've talked about this a little bit, but we have a modified joint and several liability where that we can hold everybody accountable up the chain, but we do need to prove that those people had some part in the product's liability. So finally, I just want to end on this. It's really important in a product liability case to preserve the evidence. I mean, in almost more important than any other type of case we're talking about here, because that product is something that we actually need to have our experts look at. If you just tell me, hey, this hair dryer blew up on me and it burned the side of my face, and now I had to have plastic surgery, but I threw the hair dryer away. That case is very, very tough. We need an expert to look at that hair dryer and say, here's what went wrong with that hair dryer. Break it down and give us a report. I'm not an expert at that. You're not an expert at that. We need somebody that can come in and actually look at that product. The company that you're going to sue or that you're going to bring a claim against also needs to have the ability to look at that product and inspect that product and go, okay, hey, we get it. Here's what's wrong with that product. In that situation, manufacturing defect is going to be a lot easier to prove if everybody agrees, like, hey, in this particular one, we really messed up. So they're going to fight you a little bit harder on design defects, probably, and marketing defects. But a manufacturing defect, if an expert comes in and says it's there, it's really, really important to keep that product. So if you've sustained an injury from what you think is a defective product, make sure you keep that product call my law firm. We offer free consultations for product liability cases. There's no risk to you, no fees to you unless you win. Keep that product, talk to us, let us talk you through the process, and we'll see if that's something that we need to come out and have somebody inspect that product to make sure that your rights are preserved and make sure that you receive maximum compensation.